Senator Renuka Sagramsingh-Sooklal.
Mr. Vice President, I thank you most sincerely for the opportunity to jump into this debate. So much has been said by, of course, the government bench, members of the opposition, and even the independent senators. So my intervention, Mr. Vice President, of course, the Honourable Minister of National Security and my learned senior would have gotten into the crux of the intention of the government in of course, moving this bill today. My intervention, Mr. Vice President, will of course be again to deal with certain things put on your record, of course, by the opposition senators. And as I go along, of course, any other concern, other concerns, of course, one raised particularly by Senator Paul Richards. I just want to add my 2 pence to the debate and see if I can play a part in assisting Mr. Richards, Senator Richards, to understand perhaps why certain amendments are brought here today. You know, immediately, Mr. Vice President, I want to again address certain comments made by the Honourable Senator Lakshmi Dayal. You know, Senator Lakshmi Dayal took copious notes, mentioned that, you know, the issue of firearms, crime and criminality requires a constant review. The senator also said to treat primarily with the issue of threats to prisoners. You know, but what is surprising is that the senator also mentioned since December 2021, the decision was handed down in Vishal Singh, and why we as a government, why we are here so late to bring forward this debate in an attempt to protect prisoners. And you see, I know the Honorable Attorney General mentioned it in his contribution, but again, for the record, I want to remind this country of a JSC November 2013. And in that JSC, I know that the Honorable Attorney General made mention generally about that JSC and the findings in that JSC. But you see, the opposition came here today via Ms. Lakshmi Dayal and asked the question suggesting that this government is late in treating with the issue of prison officers. But you see, Mr. Vice President, in that 2013 JSC, we had 3 members of the People's Partnership sitting in that JSC. We have Senator Emmanuel George, who was the Minister of Justice, because back then they had a ministry for everything. We had Senator Gary Griffith, who was the Minister of National Security. And we have a senator who sat in this Senate, Mr. Wayne Sturge, attorney at law, who sat in that JSC together with other members. And what is surprising is since 2013, and then since 2013, recommendations were made relative to the prisons. And I will summarize that. One of the major recommendations was to give priority consideration to applications made by prison officers for firearm users license. These applications were to be prioritized by the Commissioner of Police. That was a recommendation made in 2013 in a joint select committee in which 3 opposition senates, 3 opposition members sat. And Mr. Vice President, in 2013, 14, 15, and I always calculate the days and time, that we are a year late since the judgment. They were about 3 or 4 years late and did absolutely nothing to improve the conditions of prisoners during that time. There's a JSC report to that effect. So when they come here, when Senator Lakshmi Dayal constantly comes and she speaks about the lateness of the government, she speaks about us being, I think we intellectually bankrupt. I always put back a question to the Honorable Senator. When your government, the government that your party, sorry, the one that you support and you defend, when you all had an opportunity to make it right again, I am not saying, so this is not make up. The hands are the records of the parliament show. When you all had the opportunity, absolutely nothing was done. So in my estimation, we come in a year later from the 2021 decision given by Vishal Singh. We're not too late in trying to bring amendments to, of course, improve the conditions and to put our first response officers in a position where they can better protect themselves. So I just had to, again, read into the record that particular JSC finding. You know, Mr. Vice President, and this is now very serious matters. A question was asked by Senator Lakshmi Dayal, also paying attention to the case of Vishal Singh. She said a police officer was severely shot and wounded by a prison officer. I agree. I read the entire judgment. She asked about the criteria for the granting of a firearm, because of course the amendment that we have brought does not specifically speak to the criteria in which will be considered. But for the purpose of the public listening on, for the purpose of the independent senators in particular, Mr. Vice President, what I must remind this Honorable Senate is that notwithstanding the so we have this amendment that we are bringing in the law today, but there is an order 91 which speaks to the policy consideration that is still in existence, and the policy consideration that of course is going to guide the Commissioner of Prison in making a determination as to whether or not he is going to grant a firearm to an at-risk officer who make the application to have that to be allowed to keep and carry a firearm beyond his working hours. So I want to read into the record, and that policy is critical because what it helps us to understand is that notwithstanding the fact in this amendment, we are now giving, yes, we are giving to the Commissioner of Prisons the opportunity to make a decision as to whether or not he's going to grant an at-risk officer the permission to keep and carry his firearm. Notwithstanding this fact, we must remember this Commissioner of Prison is not going to be acting on a frolic of his own. In making said decision, the Commissioner of Prison is guided by the General Order number 26 of 2016. Senator Lakshmi Dayal just referred to it as Order 91, but that General Order number 26 of 2016 is critical for the members opposite and for the public to understand what is happening and what is going to be the guiding principle in policy, which is now married with the law, which is the amendments we are bringing here today, that will guide the Commissioner of Prison in being able to make a decision in whether or not an officer who makes an application to be able to use a firearm, whether he should be granted that application. So, for example, so in this specific order, and this is why I want to read it into the record so that the public understand what this order speaks to and understand that we are not making law vike. We have taken into consideration that this 2016, as I said, order number 26 of 2016 is still the guiding principle. Now, this order came into effect on the 11th of July 2016, and it still remains the policy. It remains the Trinidad and Tobago Prison Service Firearms policy. And let me read into the record what this policy, a little snapshot of what this particular order speaks to, Mr. Vice President. The order created the Prison Threat Assessment Committee, and I know some members would have generally mentioned it, but for the benefit of the public, let's understand what the Prison Threat Assessment Committee does. Now, this is a 3-person committee, Mr. Vice President, comprising of a member of the Prison Service Executive, a member of the Strategic Operations Unit, and a member from an organization either from the TTPS or the Trinidad and Tobago Defense Force. So yes, while in law today we are asking that a Commissioner of Prison, the Commissioner of Prison can then grant the permission to an officer to use his firearm beyond the working hours, we must remember this order, the composition created in the General Order number 26 of 2016, which speaks to the Prison Threat Assessment Committee, a committee who is going to be charged, Mr. Vice President, with the responsibility, of course, advising the Commissioner of Prison before he makes a decision as to whether or not he ought to grant a license or permission to the officer who may apply to use a firearm beyond working hours. Now, this order is so critical because even in this particular General Order 26, of 2016, Mr. Vice President. It even speaks to the timeline for decisions. And the timelines, for example, what was mentioned in this particular order is that decisions are to be made within a reasonable time. So it means that if an at-risk prison officer makes an application to the Commissioner of Prisons, setting out his case, stating that he believes that he's at risk and so on, the Commissioner of Prisons is guided by this policy, the contents of General Order number 26 of 2016, which says that even in his deliberations and even in making his decision, he has to make that decision within a reasonable time. Of course, unreasonableness of time making that decision is critical, because it means that an application is not just going to sit on the desk of the Commissioner of Prisons for however long. The Commissioner is now guided again by acting on this application in reasonable time. This particular order, Mr. Vice President, also speaks about the determination of decisions. What it says is once the Commissioner of Prison finds that the risks associated with the threat is significantly high, the Commissioner of Prisons would give approval for the officer to be issued with a firearm and ammunition, as well as other protective gears. And of course, the order goes on to speak about where decisions are rejected and so on. Now, again, Mr. Vice President, why am I focusing, or why have I focused on the General Order number 26 of 2016 is to specifically deal with some of the concerns that people may have, the public may have, members of the Senate may have, with why are we giving a Commissioner of Prison the power to make a decision on who he's going to grant this particular license to use a firearm beyond their working hours. And I just want to remind this Honorable Senate, remind this country that the policies that were created, the policies that are existing in the General Order number 26 of 2016, this remains the guiding principles for the Commissioner of Prison. So it is not that the Commissioner of Prison is going to act on a frolic of his own. It is not that the Commissioner of Prison is not, he is certainly restricted by the contents of the policy and what exists in the order itself. And this certainly, I'm hoping that it allays some of the fears that persons may have relative to, okay, well, now the Commissioner, he is the one who making the decision as opposed to the Commissioner of Police. Understand that there is this Order 91 that is in existence that creates the policy and is going to guide the decisions and explain, and of course it gets into the role of, as I said before, that risk assessment committee, who's then going to serve, and I mentioned the composition of that committee, who's then going to, upon whose advice the Commissioner of Prison, of course, is going to act in order to make a decision as to whether to grant a firearm or not. Now, Mr. Vice President, a critical question was asked by Senator Richardson. I'm glad that the Honorable Senator is here, and I know, and he asked it, I know, with a genuine concern about ministerial interference. Of course, the opposition, of course, they will go ahead and create and try to promote the rhetoric that, you know, we're trying to, the politicians, again, this government has some nefarious reason, because I think Senator Lachmidial said that as to why, you know, when the question was asked, I think the senator said, under no circumstances should a minister interfere, and she suggested that there's some sinister plot by this government to interfere in the issuance of the extension of these licenses. Now, Mr. Vice President, of course, I know we have listened. I'm sure that that is why the Attorney General and some other members are in discussion. We are listening to what the independent senators particularly are asking, because it's from a genuine place of concern. And of course, a decision will ultimately be made as to how we will treat with this particular clause. But what I want to do, Mr. Vice President, especially, I want to debunk the suggestion or the inference that there's a sinister plot behind this particular amendment. And here's what I will do to try to attempt to debunk that view. Mr. Vice President, one would think that an attorney at law, as Senator Lachmidial, would know that there are other critical pieces of legislation that exist on our books, not created by the PNM alone, but from administration after administration, in which you have a minister playing a hand in certain decisions and extensions. So, for example, the senator spoke about the Liquor License Act. Mr. Vice President, if I may look at Section 5(1) of the Liquor License Act, for example, because she mentioned the Liquor License Act and suggested that the minister plays no part there. Mrs. Vice President, Section 5(1) of the Liquor License Act, Section 45(1) of the Liquor License Act, Section 47 of the Liquor License Act, Section 59 of the Liquor License Act, Section 68, Section 82, Section 83, Section 83(8)(a), Section 83(a). All of these are sections of the Liquor License Act that speaks about ministerial intervention. And it speaks about ministerial intervention at different levels. And so when that law was passed, and mind you, this is an Act 27 of 1955, amended in 2014. Back then, I would not want to believe that there was a nefarious reason for ensuring that a minister played a part and played his hand in certain licenses, or the grant of it, or the extensions of it, recognizing, Mr. Vice President, that we as the executive and the policy drivers, of course, sometimes there is the need to intervene. And there is legislation on the book that is good law, that is existable. You always, the opposition has challenged everything. Challenge that. Challenge the Liquor License Act if you have a problem with the minister playing a part here. But that is an existing law. Mr. Vice President, if we look at Section 36(1), Section 36(1) of the same License Act that so clearly Senator Lajmial didn't do her homework before she came because she couldn't mention the Liquor License Act. Section 36(1) of the Liquor License Act, Mr. Vice President, it says, and I read into the record, the minister may, in his discretion, authorize listen to this one, in his discretion, authorize a licensing committee to grant a certificate for the issue of a renewal of a spirit dealer's license in respect of premises situated in any part of Trinidad and Tobago. Again, you see ministerial discretion.
Senators on the other side, kindly allow the good minister to make a contribution. The level of crosstalk is a little too much. Senator Leida, whilst I'm on my feet, your prop you were using just now to engage humor is not acceptable either.
Thank you, Mr. Vice President. So I want to start from the place by debunking that ridiculous suggestion that the purpose of this legislation and the amendment that we are bringing here is because we have some ulterior motive. My saying to that is only if you have cocoa in the sun, then freight raid. But that is not the reason why we are bringing this amendment here today, Mr. Vice President. There is existing law on the books that you have seen ministerial interference. For example, and not interference, but where a minister has a discretion. That is the word I should use. A minister having. If we turn, for example, to Mr. Vice President, and again, I go back to the center because she's the lawyer here. We have the Immigration Act. 10(5), Section 10(5) of the Immigration Act. You see ministerial intervention as well, and minister being able to intervene again. Section 10(5), this deals, Mr. Vice President, specifically with entry permits. Under this specific section, Mr. Vice President, it says, and listen to what it says, the minister may at any time in writing extend, vary, or cancel a permit. This exists on our books as a piece of law where you have a minister being able to vary, he is able to extend, he is able to cancel a permit. It's on the books. So again, Mr. Vice President, to come here and suggest the amendment that we are bringing is because we have some underneath. You see, the UNC judges us by their own standards and they can't get away from that. That is their biggest problem. Because every time they pass and they do something is because they had an under-the-table reason. But we don't operate like that. And that is why, for the benefits of the sober-thinking people of Trinidad and Tobago, the sober members of the Senate, I want you to understand that even if at the end of the day, the decision, if at the end of the day, the decision is taken.
Hey, members, the level of vicious crosstalk is a little too much. It's becoming vicious now and personal. Kindly desist.
Mr. Vice President, thank you for your protection, but don't worry, my skin very thick and I could take it. So anyway, so Mr. Vice President, as I said, so we have the Immigration Act, and then again we have the Gambling and Betting Act, Chapter 1119, Section 40H1. Again, in that particular section, Mr. Vice President, it says, where the board refuses permission to promote a contest, the applicant may within 2 weeks apply to the minister to review such decision. Again, you have ministerial discretion. So the point that I'm making, Mr. Vice President, by reading into the record exists, and there's so much more, but I have limited time and a lot to say. There are pieces of legislation that already exist in our books in which we have seen that a minister has the power to extend, and it's not done with the purpose of a nefarious or under the table reason, Mr. Vice President. It is because, of course, the executive, who are the drivers of the policy, that their intervention would be required. Now, Mr. Vice President, now, if the question may be asked, I know in the other place, this was discussed briefly. We would have seen, and I want to put it on the record again here with respect to the minister having the power to extend. We saw what happened with COVID-19, Mr. Vice President, and we saw with COVID-19, there was a need for, at that stage, for the minister to intervene, different ministers at different times to intervene to extend license, all right? So, for example, Mr. Vice President, during the pandemic, we had the government would have had to introduce via several miscellaneous provisions in 2020, several extensions varying aspects, whereby you would have had the validity of certain licenses were extended. We had, of course, our Trinidad and Tobago driver's permit. We had, well, I went through length and breadth the liquor license, some of it. We had even the Old Metal and Marine Stores Act. Certain those licensings were extended by who? Under the hand of the minister. All right. Now, a question may arise, why not give the power to extend by the Commissioner of Police rather than a minister having the power to extend? Now, Mr. Vice President, most respectfully, I am almost, I could address this particular issue if that question arises by reading into the record, Mr. Vice President, that in my respectful submission, I believe that the only time the Commissioner of Police would have the autonomy and the authority to extend time, that could be found, that can certainly be found, Mr. Vice President, when a state of emergency, for example, is declared under the special emergency powers. Now, under the special emergency powers, for example, most recently, Mr. Vice President, in Regulation 311 of the Emergency Powers Regulation 2021, Legal Notice 142 dated the 16th of May 2021, we saw that the Commissioner of Police was then granted the power to extend time. As opposed, and this to my mind, respectfully, Mr. Vice President, are the only circumstances in law, in existing law, that I believe that a Commissioner of Police is, while we are under a state of an emergency, that a Commissioner of Police has the power to extend time, as opposed to a minister where we could create statute and allow it. But as I said before, Mr. Vice President, I know ultimately the government bench will take into consideration some of all of these submissions made by especially the members of the Independence bench relative to this particular issue of ministerial, for want of a better word, interference, as they have put it. And I'm sure that we will make a prudent decision, of course, that is good both in law and policy. But I had to address the issue, especially to debunk the notion that this was being done with some ulterior motive in mind. Now, Mr. Vice President, Senator Richards asked another very important question. The Honourable Senator asked, what is preventing the Director of the SSA or the Commissioner of Prisons from making a recommendation to the Commissioner of Police for the at-risk officers to, of course, be allowed to keep and carry a firearm? And most respectfully, my two pence to, of course, and I'm sure the Minister of National Security in his winding up will deal in more detail with this issue. But most respectfully, I can foresee that if we place this again on the, even though yes, we know the grant of FULs and the grant of these licenses already falls squarely on the Commissioner of Police in the current incarnation of the law, if we have a lot of applications, added applications from prison service, from prison officers, we can look at the issue, of course, of another administrative bottleneck existing on the desk of the Commissioner of Police. And this was one of the particular reasons why I personally supported moving this responsibility from the Commissioner of Police to the Commissioner of Prison, who is equally qualified, who is charged with the responsibility of running and administratively the prisons. And more so, I would have read into the record Order 91, he is now supported by this risk assessment committee. There is a policy from 2016, a copious document. Maybe the opposition should take some time and read it, which of course gets into detail as to what will be the guidelines in issuing a prison officer the opportunity to keep and carry a firearm beyond working hours. So I personally, through you, Mr. Vice President, to Senator Richards, I believe that the Commissioner of Prison, of course, supported by the provisions provided in Order 91, can certainly make a decision that will be in the best interest of his officers. And why I spoke about the administrative bottlenecking as well, remember the Commissioner of Police, together with their ordinary responsibility, together with her ordinary responsibility, we have other applications that falls on the desk of the Commissioner of Police. We see it most recently with the sex registry. We see with pepper spray applications. There are other, yes, we know by certain administrative orders. We know the Commissioner can delegate responsibilities. We know all of that. But to my mind, most respectfully, Mr. Vice President, even in assisting the Office of the Commissioner of Police from having to deal with these applications, because mind you, in that same policy, spoke about the fact that prison officers who making these applications, they would also be subject to the same kind of mental assessment, and this is the kind of review that this committee who would advise, of course, the commissioner. This is the kind of investigation that they do. Imagine that now resting with a commissioner of police who already has their ordinary responsibilities. You have increased responsibilities with pepper spray applications, sex registry, and the list goes on. I respectfully believe, Mr. Vice President, that a commissioner of prison who is equally qualified should be charged, most respectfully, with the responsibility to make such a decision. And so that is with respect to of course, that concern. Now, Mr. Vice President, I know Ms. Senator Gillian John spoke about the municipal police, and actually in the crux of my presentation, Clause 5 of the bill was just something, Clause 5 and Clause 7 of the bill, which speaks about the SSA. Those are two areas that I want to briefly be able to address. Mr. Vice President, can you tell me how much more time for full time?
You are to finish at 5:48, so you have about 11 minutes.
Okay, thank you very much, Mr. Vice President. So, Mr. Vice President, if I may now look at Clause 5 of the bill that appears before us. And, of course, Clause 5 of the bill speaks specifically to municipal police officers. And I have to, of course, say that the Assistant Commissioner of Municipal Police, I know he is very, very hardworking. He is none other than my father, and I know he's assisted quite ably by a lot of. I know he's quite ably assisted by a lot of hardworking officers of the municipal police. Now, in dealing with this particular clause, Mr. Vice President, I know others before me would have gotten into detail about the municipal police. And the municipal police, of course, they are very much charged with similar responsibilities and tasks as the ordinary TTPS, the Trinidad and Tobago Police Service. There are only two distinctions, Mr. Vice President, that exists between municipal police and regular police. And one, municipal police are limited relative to their investigative powers and the capacity they have to investigate criminal offenses, serious criminal offenses. And other than that, so that is one of the major distinctions that exist. And of course, they are not allowed to use automatic weapons. Mr. Vice President, I want to, and the reason why I'm making this point is because municipal police officers, this amendment, I lend support for it because, of course, they are also at-risk officers. I want to debunk any view that members of the public may have if the belief is that municipal police, they primarily are rotten tomatoes police or they're market police. I want to debunk that view, Mr. Vice President. And that is why I would have read into the record some of the responsibilities. So some of the I want to read into the record, sorry, Mr. Vice President, some of the responsibilities of municipal police is to facilitate the maintenance of law and order, of course, within a municipality, to provide security at corporation meetings, and to ensure the safety and protection of staff and individuals as well as corporation property assets. Municipal police are to adequately enforce the municipal bylaws and regulations of the council to facilitate any prevention of crime and infraction. And there's a list of responsibilities. Why I've gotten into just a few, of course there's a list and there's not enough time to get into it, it's just so that the members of the public understand how critical even these municipal police are to policing in Trinidad and Tobago. And as a consequence, I support the amendment in which we're not trying, because mind you, we're speaking about pepper sprays and tasers here for municipal police. This is simply to even the odds. This is not to put municipal police officers in an advantageous position, but it's to simply even the odds that should an officer find him or herself in a position where he is now or she is now required to defend themselves, at least they have a different level of protection. And that is the protection, of course, Mr. Vice President, that this particular bill provides, that the amendment that we are seeking here today will provide. I know Senator John spoke about whether or not, and of course Senator John would have gone into tasers, and I believe she would have made mention to research that she would have done that spoke about the seriousness of tasers. Now, I'm pleased to read into the record, Mr. Vice President, in July 2016, the government agreed to the creation, as we all know, of 1,107 additional positions of the municipal police, to the municipal police, and that was to be spread across the 14 municipalities, right? But beyond that, Mr. Vice President, what we also have in existence today is the Municipal Police Academy, which was established in July 2018 in the Old Marabella South Secondary School. And why I'm bringing up this particular academy, Mr. Vice President, is because Senator John would have spoken about tasers. She would have spoken about whether or not training, but of course the seriousness of the tasers as well. And what I'm pleased to remind the people of Trinidad and Tobago and the Senate is that we have at the Old Marabella South Secondary School, Mr. Vice President, a municipal police academy that is up and running and that is functioning, and that once this amendment, of course, is brought in the law, what you can rest assured, I am certain, is that the level of training at the academy will be increased in order to allow these officers the training that is required in order to treat with these tasers, to deal with pepper spray. Now, to that end, Mr. Vice President, I understand that Mr. Curtis Belford, Senior Superintendent who runs that academy, I understand that he's very hardworking and he's actually one of the person who spearheads the various levels of training that the academy provides. And mind you, some of the levels of training that the academy provides, Mr. Vice President, is in the area of operations. We have Operation Task Force Unit. There's the police skill section. There is the quartermaster stores. There's the development training section. And why I'm getting into this, Mr. Vice President, is to lay any fear that the public may have, that even the opposition may have, about putting tasers in the hands of municipal police officers. Whether or not they would be trained, whether or not they would be able to deal with this. My answer to that is that I am certain the municipal police officers will, once the amendment to the law comes into being, this school, this academy that is already up and running and that is so critical in the training of municipal police, I am most certain that under one of these units that are already in existence, that this additional training will be provided to the municipal police, Mr. Vice President, to be able to allow them the opportunity to be able to, of course, properly handle tasers, properly handle pepper spray, and so not put the public in harm's way if and when, God forbid, there's a need for the officers to have to use the pepper spray or the tasers. That is important, Mr. Vice President, of course, for us to understand. So on that realm, on that point of training, Mr. Vice President, I am sure that the necessary amendments will be brought up. Now, of course, Mr. Vice President, again, one of the major reasons why I also support the amendment being brought in the interest of the municipal police is because apart from having all of the rules and a lot of the similar rules and responsibilities of police officers, remember municipal police are really the ones who spearhead, for want of a better word, community type policing, the softer side of policing. And of course, being in the communities, Mr. Vice President, God forbid again, if for some reason the municipal officers find themselves in a position where they also have to protect members of the communities in which they exist in, the amendment that we are seeking to bring in the law, Mr. Vice President, will again not put them in an advantageous position, but simply even the odds and allow the officers the opportunity to, of course, be able to protect not just themselves, but to protect the communities in which municipal police officers are working. Of course, and this, Mr. Vice President, in essence, is one of the major reasons why I would certainly support the amendment that proposed clause 5 of this bill seeks to bring. Now, before, in closing, Mr. Vice President, I just want to briefly put on the record why I support Clause 7 of this bill. And Clause 7 of the bill seeks to repeal and substitute Section 8 of the Act to provide that an officer listed in Section 7(1)(a) and AA, which would now include municipal police officers, and this is a specific part I want to focus on, and the director and an employee of the Strategic Services Agency, the SSA. Mr. Vice President, very, very briefly, why do I support the SSA and the amendments that have, not the SSA, but the amendment that we have brought today relative to the SSA, Mr. Vice President? I just thought that it's pertinent for me to read into the record, Mr. Vice President, the amendment that we are bringing today and the allowances that we are providing to the director of the SSA is no different from what exists in regional, in countries in the Caribbean region. So, and most similar to Trinidad and Tobago, and the amendment we brought today, I found when I turned to Jamaica. Mr. Vice President, in Jamaica, this agency has similar duties. There's an agency that exists in Jamaica, Mr. Vice President, that has similar duties such as the SSA in Trinidad and Tobago, such as to promote and protect public safety and national security, and to promote and strengthen measures for the prevention, detection, investigation, and prosecution of serious crimes. But what is important, Mr. Vice President, to read into the record, and this section in the Jamaican law is very similar to the amendment that we are bringing here today. Section 46 of the Jamaica's Firearms Act, it states, Mr. Vice President, an officer designated by the Director General of the Major Organized Crime and Anti-Corruption Agency under the Major Organized Crime and Anti-Corruption Agency Act is exempt from the requirement of holding a firearm license. And this, Mr. Vice President, I believe it was critical because, again, there's always the belief that is promoted by those opposite that we create law vice. This is to show the members of this Honorable Senate that even in bringing forward this particular particular amendment, as seen in Clause 7, it is very much aligned with the law that exists in Section 46 of the Jamaica's Firearms Act. And that particular section, that act, Mr. Vice President, of course, speaks to giving the director of these agencies the opportunity to now be exempt from having to go through the rigorous process of obtaining a firearms FUL, regular FUL license, recognizing the line of duty, their job, what their job entails. There's also another comparative. If we look outward at Australia, we look at Canada, we look at South Africa, Mr. Vice President, the Australian Security Intelligence Organization, known as the ASIO. In Australia, Mr. Vice President, what we see is that there's also existing legislation that allows officers who sit in these organizations to be exempt from holding a firearm license. In Canada, the Canadian Security Intelligence Service, if we get into the legislation and the regulations that govern that organization, who's similar again to the SSA, we have that their directors and members who sit there are again, they fall on an exempted list. South Africa, Mr. Vice President, the State Security Agency, similar again to the SSA, Mr. Vice President, we have that officers who form part of that organization are similar to what we are hoping to achieve today with the support of those opposite, with the support of the independent senators. Would they have similar provisions as Clause 7 in the bill that appears before us? And I believe it was critical to read that into the record so that one can understand, the public can understand that by the amendment that we have brought here today, it's very much in alignment with not just regional compared to Jamaica, but Australia, Canada, South Africa. So, Mr. Vice President, of course, I want to again add my support with the members of this side to the Minister of National Security, and of course commend this bill to members of this Honourable Senate. I thank you, Mr. Vice President.
Senator Mark.